hear me, you are free to log out. And Mr. Kiernan, I appreciate your docket management, making
Yeah,
sure that
that
Ms.
was
Baldwin called last so she could take her other case. Well
yeah,
done.
I felt like it was the most responsible way to do it. Thank you.
All
Thank
right.
you.
So that leaves us with number one, 252-35408 with Ms. Baldwin and Mr. McKay. Villages at Beaver Creek LLC, represented by Ms. Baldwin. And then and Mr. McKay, I believe are you for Wendy and John Rodriguez?
Well, I think effectively, yes, Your Honor. They're a
Okay.
married couple. Technically, NJP is representing Wendy Rodriguez.
And Ms. Waldvogel, are you here as well? Are you able to hear me?
Your Honor, I am. I'm just observing today.
Oh, okay. Understood. Okay, well, I'll turn it over to the parties. I have this on to review for the CR2A compliance or enforcement of CR2A. I'll turn it over to the parties.
Thank you,
Your
Your
Honor,
Honor.
I'm just
Oh.
nervous that my boss is on watching me. I just want to note that for the record.
That will be noted for the record. Well done, Ms. Waldvogel.
So we are on for CR28 compliance. This was a failure to pay from quite some time. There was a large arrearance that was present. The parties reached a CR2A to prevent essentially the eviction. But that CR2A required compliance. And because we had a long history of non-compliance, where folks just don't pay, they're going to kind of make issues with payment and never actually get around to paying. We said, okay, you've got to pay the arrearage, including the month that we were in at the signing of the CR2A, all complete. And then, because essentially there was no trust that they would pay going forward, there was essentially checks along the way to ensure payment. And so that's where we are, is they've made that initial payment. Yes, the very next month they fail to pay. And so in this case, we do have an underlying CR2A that says what happens here. And what it says is if she does not pay by the date certain, that the court will issue the writ. And in this case, the date that they had to pay by was even later than the contract. So the contract sort of like pay on the 1st and late by the 7th type of a thing. This allowed them to pay even later than that. So they were already being afforded more than their contract by the CR2A. And what we have is, once again, no payment. We're set for review to say, hey, if they didn't pay, we're entitled to a writ. This is not where we get to sort of continue to play and dole out, different reliefs. The parties have already sort of set the parameters. And if the court doesn't abide by those, there's no reason for people to ever reach agreements. The agreement has to benefit both sides. People have to get the benefit of the bargain. And these folks are just never going to pay or never pay timely, which causes cascading problems on my client's side. That's always sort of ignored, that the reality of it causes notices, it causes extra hearings. Like this hearing shouldn't have, if they had paid timely, this hearing wouldn't have happened. So my clients are here paying additional amounts for me to be here just to enforce the CR2A. So in this case, we are entitled to the CR2A. We're entitled to the rent that's due and owing to be a judgment. We are entitled to a late fee. I would argue we are entitled to attorney fees for my presence here today, and for my client having to issue her declaration. The response is effectively, well, hey, because they didn't clear it in their personal ledger, so again, not a judgment, not seeking a small claim, because they didn't clear it in their judgment, I said nothing, I did nothing, I paid nothing, but I should just get to stay for free. There's no money that they have paid since. There's no money that they have paid to my office. There is no money in the clerk's registry. So again, the argument is from them, I just get to stay for free. I've said nothing, done nothing. If this was some sort of problem that they noted, they said nothing to anybody until this matter was put on for review. And again, my clients have not sought payment from them other than what's in the CR2A. They have not created judgments, and they have not sent the matter to collections, none of that. So my clients have abided. These folks have not paid. Again, they're entitled to the benefit of their bargain. These are folks that have not paid historically. They will not pay going forward. My clients just want them out and want to be done. That's reasonable, and that's what the CR2A says. So we're asking for that writ.
Thank you. Mr. McKay.
Yes, I think the facts recited by counsel are almost entirely incorrect. there was a significant payment made here as part of the settlement. First of all, Your Honor denied the writ and ordered this case to be set over for trial. The day before trial, it was settled, and the settlement agreement is therefore what is before the court. In that settlement agreement, my clients paid over $8,000, all of the arrearages. And the question is what happens going forward? And the agreement, of course, is to the benefit of both parties. Paragraph 4 of the agreement, which is attached to my client's declaration, requires that the claims be released by the landlord. When my client went to the payment portal and saw 3 times the amount that was due showing on the payment portal, that is the ledger of the plaintiffs, she did not make the payment. So the release obviously was not complied with, and they are in breach of the release. So my argument is quite simple. They can't claim relief under the settlement agreement when they are in breach, and it's a clear breach of paragraph 4, which is a mutual release of claims. My client is a dialysis patient, very difficult to reach. I did reach her this week. I didn't know anything about this. And it's clear that the client was in, full compliance with the agreement until it became clear that the release had not been entered into. So, if Your Honor, I presume Your Honor has my client's declaration, which sets forth screenshots of the ledger of the landlord. And I just want to note, as I conclude, Your Honor, that this is the very issue that you found a question of fact and set over for trial. The plaintiffs were maintaining that the rent for March was due. My client was maintaining that it was paid. We submitted declarative proof to you of that. You found a question of fact and set it over for trial. So the matter was ready to be fully tried, and then we had the settlement agreement. Now, the release was particularly important to my client because of the claims being made by the landlord of rent which was due and owing when in fact it was not. And that's what's happening here. As you can see from the screenshot, it shows about $5,800 due and owing. My client tells me she was afraid to make that payment because it would still have a balance, and she was afraid they would pursue her as they were doing in this case in the very beginning incorrectly. So I would suggest that Your Honor deny the claim for relief of the plaintiffs. They have in the settlement agreement a review hearing set for September 12th, and I think they can note that on the court's calendar. And at that point, the court can determine whether the parties are in compliance with the settlement agreement per their agreement. And that's perhaps the one thing that I agree with counsel on, which is the parties are entitled to the settlement agreement that they entered into. Thank you, Your Honor.
So you have to use the words of the agreement. Counsel really wants to change what those words are instead of abiding with what they actually are. Let's go back to law school. What is a release? What is a release of claim? When we look at what that actually is, it is not that my client has to change their internal ledger. Instead, a release of claim specifically is where a party gives up or waives or releases their right to pursue a legal claim against another party. So my clients gave up their right to sue for those damages and sue for those amounts owed. It does not mean they have to change their internal ledger, and nowhere in this agreement does it say that. The purpose is to provide finality for my client and for Mr. McKay's client. So that release is binding, meaning my client can't go sue in small claims. They can't then proceed in this action and ask for that limit. There's a limited scope. So we have just the specific dates that, this covers this time period and these things. So we have that specific scope that's limited. And again, we have the effect. It was to provide both parties assurance. She knew she couldn't be sued for that amount, but she had to pay per the agreement. So Mr. McKay wants to change what the agreement is. My client released her ability to sue. That's what she gave up. Not you are required by this order to change your ledger. She was not. So again, my client's entitled to the relief under the CR2A. They did comply. The only payment they made was for the rental arrears and utilities owed from March through July. So they paid nothing March, April, May, June, July, 5 months of zero payments on their utilities and their arrears. They make one single payment and then they've never paid again. So again, my client is entitled to the relief under the CR2A. The language in there is clear. You cannot twist it to be something else.
Are you able to tell me, so we know, and correct me if I'm wrong, the tenants did pay the $8,305, correct?
That's correct.
Okay. And then, so where does the $5,000 outstanding amount come from?
So that is just my client's internal software that's saying, hey, the software is basically saying this is the actual amount that we said would be in arrears. But again, we're not claiming any of that. We're not coming to court saying they're in arrears $5,000. We're saying they haven't paid their August rent, which is laid out in the CR2A and the utilities. So we're not seeking a judgment for that. We're just seeking a judgment for just the rent and just the utilities. So again, not seeking an arrearage of more than exactly what's in the CR2A.
Okay.
Your Honor, may I just point out one thing? I'm
Sure.
sorry. She's made two arguments. I just want to say that's the client tenant facing portal of payment. So when my client went to the portal to look at her August payment, she saw $5,800 and not the August rent, which was the only thing due and owing. So she, I don't want to say freaked out, but I would say that she was very upset that it was inaccurate and it appeared to be the exact same tactics used by the landlord. That was the underlying aspect of this case. And I'd just like to point out, they have never proven that March rent was not paid. We, in fact, proved that it was paid. You found a question of fact and we were set for trial on that. All of the other arrearages were paid over $8,000. And the only question is August rent. My client's entitled to have a correct statement of the amount due and owing before she's required to pay. That's what the agreement says. That's what the release was based on. They can't sue to enforce a settlement agreement for which they are in breach.
Let me ask this to either party. I'd love answers from both of you, but obviously I think what this boils down to is the amounts that the original action was filed based on have been paid. So we're here now under section, I think, 5 and 6, frankly, of the CR2A that talk about, hey, rent and utilities for August 2025 need to be paid, and rent and utilities for September need to be paid, and it gives a date certain for that. My question is this: in number 6, it talks about if those things don't happen, landlord can get an immediate writ. How is that? How does the Princeton Allen case play into that, where the Court of Appeals talked about you can't waive unlawful, you can't waive the process of unlawful detainer actions?
So it doesn't do that. So that's why we're here in front of the court. So my client didn't get an ex parte writ. So that case is talking about folks circumventing that and that there's essentially no judicial oversight. We're obviously before the court, so we haven't run afoul of that case. And counsel asked for specific language in this order to make sure that it withheld within that case.
Your Honor, let me just point out, I agree with you. I think there is a Princeton Properties issue here, but counsel's also correct in saying that we agreed that if we were in breach, that she could move for a writ of restitution. And so that would mean that she would need to note it on calendar, that she would need to file her writ and move forward, because the previous writ was the subject of the trial. That was found to have been a question of fact, and the court denied the writ. So she has to file for the writ. If she can't waive the Princeton property requirements, that's clear here. We did agree to that there would be no stay and that the case would move forward from there. But again, I think more than just paragraph 5 and 6 are at issue. Paragraph 4 is at issue, which is the mutual release, and they are not in compliance with that. And Your Honor heard my argument there. And I do think that it is not appropriate to grant relief to the plaintiff when they're in breach of the agreement.
Absolutely not. That is incredibly frustrating for counsel statements, in that we both agreed I would not have to file a new case, which is what counsel is now playing at, is she has to file a new case.
I didn't say that.
That's what certainly is implied. The agreement was this was actually supposed to be on last week. It got dropped from the clerk's docket. So it was supposed to be automatically on. We renoted it to get it back on. So the agreement is it was automatically on, and his client had an affirmative duty to show that they had paid, and then we would strike it off. That was the agreement. So his client didn't show that. And his statements of, well, they looked at this ledger and didn't know what to do, so they did nothing. That doesn't make any sense. And again, the release, counsel desperately wants to change what the agreement is. The release is my client releases the claims in this action as to those other arrearages, and releases that they won't sue them in small claims or, in another action. That's what my client is abided by. So if my client's abided by that, hasn't sent them to small claims, hasn't sent to collections these other amounts, that is the agreement that we had. So my client did abide. They have not paid. There's no money in the clerk's registry. They haven't tried to pay. Counsel never reached out to me. So we're in that same position where my client's abided and they're supposed to get the benefit of their bargain. His client is saying, well, I'm not paying and I'm not going to pay. And again, we see is nothing in clerk's registry. So again, my client has to, if we're ever going to do CR2As, though it cannot just be, it's a CR2A so long as the tenant gets what they want. And the second that the tenant violates, we find a way around it. It has to be that both sides get the benefit. She has gotten the benefit of the release, and that my client did not get a judgment in this case and has not sought a judgment. My client gets the benefit of insured payment, and if they don't pay, they get their writ.
Your Honor, with respect to Princeton Properties, I think the issue is, under this agreement, if she scheduled a review hearing and the relief she seeks is eviction, then she should file her papers and allow me to respond to them. That would be the due process, or at least, I think most of the due process required by Princeton Properties. She didn't do that. She noted it for a review hearing. That means she's seeking to enforce the CR2A. And my position, I've already given to the court, is she's in violation of the CR2A. And the court, if the court wants to have a further hearing, they should follow what the contract with the settlement agreement says, set the hearing for September 12th, see if the parties are in compliance. If counsel wants to bring an eviction matter, she can submit her writ papers. I didn't say she had to file a new case. She submits her writ papers so that the Princeton Properties due process can be complied with.
And if you look at paragraph 6, again, counsel wants more than we bargained for. And it doesn't violate Princeton Properties because we brought it back before the court. If you look at paragraph 6, the very first 2 lines talk about there's an automatic review hearing. So we have an automatic hearing set by agreement, and that his client had an affirmative duty to show they had paid. So counsel wants to have more than what the agreement was. And that doesn't violate Princeton Properties, because we're having a hearing. We all know what the hearing is about. It's about compliance with this agreement because we've already said what it's about in the agreement. And we already know that she has an affirmative duty to show she's paid. So counsel then says, well, gee, now what I really wanted in that CR2A was no automatic review, and she has to file a motion and do all of these other steps, which are not contemplated in the CR2A. And again, when we've already agreed, and again, we're not waiving any right. We're already agreeing on this is the hearing. This is what it's about. This is the decision the court has to make. We're already saying we're laying all of that out in advance. It doesn't waive anybody's rights. It's making them clear on their face to everyone.
So here's what I'm going to do in this case, and I do appreciate the argument of both parties. I would like, and we can pick a date, I would like some additional briefing on this. And here's what I would like the parties to both focus on. My question, my biggest question under Princeton as I read it was in that case, and I think your CR2 agreement is very different than the one they contemplated in Princeton. However, in that decision, the court talks about one of the things that landlords have to do under the act is give immediate notice to tenants to cure any alleged nonconformance. And so my question is whether your CR2A agreement allowed for that type of notice or whether it was asking to have that type of notice waived. So my question is, not my question, my request is for some additional briefing regarding what each party is requesting as it applies to Princeton. And then depending on when you want to come back on that, I'd like to come back before September 12th. I don't think we need to set it out that far.
I'd like to come back whenever your honor's ready. We'll do it immediately, but they should have to put up the full amount for August into the clerk's registry. They're non-paying. My client is once again sort of left holding the bag for the delay. And
Mr. McKay, is your client able to pay into the court registry August rent?
I don't know the answer to that question, Your Honor, but I would just suggest, where is their obligation to show that they have released the amounts that they claim they would release in paragraph 4? So I'm suggesting that the court say, when at the time of the hearing, you can determine whether the parties are into compliance. Their ledger, their client tenant facing ledger has been corrected, and payment has been made by my client. Give us whatever your time Your Honor sets aside to have for the briefing, and we'll make those showings then.
Well, go ahead, Ms. Baldwin.
it's frustrating because counsel doesn't understand what the release is. Like,
I think I know very well what the release is.
Okay.
It's
So
very
then-
clear what the release says, Your Honor.
There's no way for me to show a negative other than for my client to say, we haven't filed a small claim and we haven't sought relief to enforce the amounts that
So
were
let's-
indicated under the CR2A.
All right, so if the parties want to brief that issue, I have the declarations. You don't need to refile those, but if you want to put your arguments into the briefing, that is fine. I would suggest September 5th. If that works for the parties.
I'm sorry, Your Honor, let me just take a
Mhm.
quick look at my.
My
Well,
thought would be a mutual briefing schedule. I mean, we've been here on oral argument. I don't think there's any surprise other than the legal argument that I'm requesting some briefing on.
September
So
5th
my-
is fine with me, Your Honor. Thank you.
Okay.
The date is fine. My only concern is counsel really hasn't answered and then that's 2 months that need to be in the clerk's registry, because even if you sign then a writ, it can be up to 2 weeks before the sheriff gets them out. And so then we're in a position where we're now 2 months and it results in all of my client being stripped of all of the benefit of this agreement. And then that gets us to a place where agreements become difficult, if not impossible, to reach in the future.
So, Mr. McKay, I would like prior to August 31st, your client to have put into the court registry August rent. I think that is
Yes.
fair.
Okay, Your Honor. Thank you.
Because if their argument is we only didn't do it because we saw this $5,000 figure and disagreed with it, it does not appear that their argument is we couldn't pay it. So I'm going to take at face value that they would have paid it, but for the disagreement on the amount. So I do think they need to put into the registry by end of month that amount.
Your Honor, may I ask that at the same time, the plaintiff change its register to show the correct amount due and owing?
I don't think I have
Yeah.
I don't think I have the power to order their bookkeeping methods, but certainly it sounds like that is an issue of fact we'll discuss further on September 5th.
Okay, thank you, Your Honor.
Okay. Anything else we need to do?
Not on this matter. You set a briefing schedule. Do you want to set a schedule?
I was just going to say if both parties could file mutual briefs to the court and each other by Wednesday, September 3rd, I think that's plenty of time.
That's fine.
That's
I
fine
just
with
asked
me,
if
Your Honor. Thank you.
everyone needs to provide bench copies since there's no guarantee. Honestly, it'll be updated that quickly.
That would be really helpful. And if you, if anyone wants to just email those to Kelly Holter, that's fine too for me.
Kelly Holter.
For the bench copies, not the filing. Sorry. should
Understood.
clarify.
Bench
Yeah.
copies. Will do, Your Honor. Thank you.
All right, very good. Thank you.
All right. Thank you both. All right.